Good morning, everybody, and welcome to this webinar on the Mobility Directive and its implementation in Luxembourg. Thank you to the LPEA for organizing this webinar, and thank you to Shearman for hosting us today in their studio. I am Mélody Brunot from DLA Piper Luxembourg, and today I'm pleased to be accompanied by Victoria from Shearman, as well as Blazej from Arendt and Mélody. So today we'll go through the changes that the law which was adopted on the 23rd of January in Luxembourg will bring in terms of timeline, in terms of formalities, and we'll also focus specifically on the protection rights that have been implemented by the law and that will come into force whenever the law is effective. The first thing to mention is that although the law has been adopted, it has not been published yet. So we don't know yet, and there's still uncertainty as to the effective date of the law. And it's also worth noting that in parallel to the Mobility Directive law that we will be discussing today, there's also a bill of law currently being with the Commission on the employment aspects attached to these cross-border operations that we are discussing today. So let's dive into the topic. So what is the scope of the directive? The directive was adopted back in 2019 by the EU Parliament with the objective to set a common framework to the EU member states for cross-border operations. By cross-border operations, we target the mergers, the demergers, and also what we call the transformations or conversions, what we used to call the migrations in Luxembourg. In terms of geographical scope of the directive, it applies to EU member states and the EEA countries. When it comes to Luxembourg, any cross-border operation involving a Luxembourg company and a company from the EEA countries and the EU member states will be covered by the new law in Luxembourg. What does not fall within the scope of the directive is domestic operations, such as the mergers between two Luxembourg companies or mergers between a Luxembourg company and a company coming from a country outside of the EU or the EEA. In terms of entities, there's also a distinction to be made here, as the directive targets only three types of Luxembourg companies: DSA, DSCA, and the SAL. So all the other corporate forms existing in Luxembourg fall outside of the scope of the directive and of the Luxembourg law. So today, and whenever the law will be in force in Luxembourg, we'll have two regimes coexisting. A general one, which will apply to domestic operations and also operations which involve a country outside of the EU, and a special one involving cross-border operations within the EU, what is covered by the EU Mobility Directive. So if we look back at the objectives of the directive, there were three main objectives that we can extract from the directive per se. The first one, of course, was to harmonize the rules applying to the mergers, the demergers, and the conversions among the EU member states. Before that, and before the Mobility Directive was implemented in the EU member states, each member state had their own regime, which could lead to some uncertainty as to the formalities to be observed, the effectiveness of certain or effects of certain process, and it could also bring complexity sometimes in lengthy discussions. What the Mobility Directive also aims to, and what we see also in the law, and I think you will cover that, Blazej, later on, is the increase of the protection of the stakeholders of the company. And by stakeholders, we don't only mean the shareholders. That involves the employees and the creditors as well, and we'll dive into that a bit later on. And finally, the law and the directive clarify the legality control that these operations, the cross-border operation, are subject to, with an authority to be designated by each member state, in Luxembourg, the Luxembourg notary, who is responsible for checking and making sure that the processes have been made in line with the law and also are not abusive in any type. So let's dive into the new process as it stands and the timeline, and I leave the floor to Victoria for that.
Thank you very much, Mélody. And let's take a look at the situation as it is currently still the reality. So the situation before the law comes into effect for cross-border mergers and similarly applicable to demergers, cross-border demergers. We have, and you will all know this timeline well because we've been working on this basis for years and years. You have the approval of the merger plan or demerger plan by the boards. You have the common draft terms being published in the RCS and RESA. And then you have this 1 month waiting period that we all love so much because it just slows the whole process down, but it is the law, so we need to respect it, during which the relevant documentation needs to be made available to the shareholders at the registered office of the merging companies. After that 1 month waiting period, you have the approval of the general meetings where it is required by law, and the merger then becomes effective depending on whether you are in an internal context or in a cross-border context, becomes effective upon publication of the general meeting in the RCS and RESA. Following that, so starting from the publication date from the general meeting, you have the 2 month creditor protection period. Let's look at conversions, so what Mélody referred to and what we all refer to as migrations currently. Right now, these are not ruled by any statutory regime in Luxembourg. They're based on ECJ case law mainly. Many of you might recall that we often have discussions with other countries whether these are in fact possible or not. The ECJ has said yes. Not every country applies that, in fact, but for cross-border conversions or migrations, currently there is no specific formalities required. You do not need to publish or prepare a plan. You do not need to respect any waiting periods. There's no specific creditor protection. And you simply go to the notary by way of a general meeting, approve the migration, and then in the receiving country, so the country to which you want to move, you hold another general meeting, which is constitutive, so to say. This is the current situation. Now let's take a look at what will change with the new law. That looks painful, right?
Is it longer than the current process?
That is a very fair question. Obviously, you will see that you have a lot more formalities, and we will dissect these in a second. Is it really longer? I would dare to say that yes, in practice, it will be slightly longer, and I will explain why. I do, however, believe that the actual effect, considering, and you all know this well, clients need some preparation time around all of this, and the actual effect on, getting the deal done is going to be relatively minimal, I dare to say, assuming, and we will also get to that in a second, assuming this ominous legality control goes well, obviously. Otherwise, you will be looking at a far, far longer process, and assuming also that if you're looking at a cross-border situation, assuming that the legality control in the other country is being done swiftly, and we will dig into that. So yes, I would say in reality, for a cross-border context, you're looking at a longer timeline, unfortunately. But let's look at this in detail. Let's dissect this. Mélody, you said it. We have now a special regime for cross-border mergers in EEA member countries, and we have the general regime that applies to mergers, domestic mergers or cross-border mergers with non-EEA countries. And the other change with respect to migrations is that it is now finally governed by a statutory regime. What changes for non-EEA and domestic? mergers and demergers? Well, there's a few changes that are being made to the law in order to align the regime applicable to non-EEA and domestic mergers and demergers to a certain extent with the new EEA regime. There's going to be, there's an exception for the preparation for the board report and expert report that is previously required and could only be waived for single member companies, as the directive and the law says. What does that mean, single member companies? Well, we looked it up because it's not necessarily clear to everyone, and based on the reading of the German translation of the directive, this is indeed, and that's good news, and that of course obviously also makes sense, it is sole shareholder companies. So for companies with sole shareholders, there's no longer a need to prepare a board report or an expert report. The law now also expressly mentions that the general meetings may approve the mergers subject to a condition, which the accomplishment of which can then be acknowledged either by the board via acknowledgement deed or by the general meeting. This was previously done in practice, at least we did it, but we often had a situation where in other countries this was not possible. And we all know if you have regulatory conditions, etc., this is quite important to have. The legislator has also added the necessity for a notarial certificate confirming the accomplishment of all formalities under Luxembourg law for a cross-border merger. This again is to align with the formalities required for an EEA cross-border merger, which we'll look into in a sec. Another thing, and that is quite interesting, is that we have added the possibility to run with a simplified merger process that we previously knew for upstream mergers, so a simple merger of a company held by a sole shareholder into its sole shareholder. This is now also possible in form of a side stream merger, meaning that if a company, an absorbing company, is held directly or indirectly by the same shareholder as the absorbed company, and you do not want or need to issue shares, you might need to for tax reasons, for instance. So if you don't need to issue shares, then you can proceed with this simplified merger formalities, which we love so much because we don't need to respect a certain number of things, such as the board report, etc. Interesting point here to note is that the law clearly states directly or indirectly owned. That means that we're not only looking at sister mergers being possible, but also at aunt-niece mergers. So if you have an indirect relationship that are being possible to the extent that the ultimate shareholder at the top is the exact same sole shareholder. The effective dates of the merger and the demergers haven't changed, which is a good news, so we don't need to change our habits for non-EEA and domestic proceedings, so nothing new there. Let's now take a look at the new EEA cross-border merger regime. All of the above, all of what I just said applies, except that the conditionality is only possible for the implementation of workers' participation rights. This, in my view, is unfortunate. Why not extend the possibility for conditionality in general, as we have done it, as the legislator has done it for cross-border mergers that are in a non-EEA context? So this certainly is something that will need to be discussed and that the market will need to take a view on in the future. And in addition to all these new slight changes, you have a certain number of additional formalities, which is why the slide that you were looking at before looks so crowded all of a sudden. First one being is that you now need to have a board report with two different sections. And the section for shareholders, looking at shareholders, is waivable, as was the case before, and is not required for sole shareholder companies, as I explained just earlier in this webinar. However, there's a second section or a second report at the choice of the company that needs to be addressed to employees of the companies, and that section is not waivable under any condition. And the only situation in which this will not be required is if you have a company that has no employees other than members of the management board. So as soon as you have employees that are beyond members of the management board, you will be obliged to prepare this employee report. And now comes the first extension of our timeline in reality. This report will need to be made available to employees in electronic form at least 6 weeks before the general meeting. So this needs to be made, if you take the assumption that all the documentation will be ready at the same time, so your common draft terms of merger as well as your report relating to employees, because that's how it is going to be in reality, you're not only looking at the 1 month mandatory waiting period upon publication of the merger plan, but you're looking actually at 6 weeks during which this report needs to be made available to the employees. So this is our first 2-week extension. If you want to do the maths, Mélody, we will add everything up at the end. Then the next new thing, and we mentioned it quickly before, Mélody mentioned it already, is that we have a pre-merger control, which in Luxembourg needs to be done by the notary. In many, many other countries, EEA countries, this is done by the commercial register. In this pre-merger control, the notary or the register needs to check that all formalities have been complied with and that the operation is not undertaken à des fins abusives ou frauduleuses ou criminelles, says the law. So basically, the notary will need to take a view and confirm that the transaction is not done for abusive, criminal, or fraudulent purposes. And for this merger control, and now comes the second extension, for this pre-merger control, the notary or the register has 3 months, which may be extended, but let's not discuss that extension too much because it's depressing. 3 months, which we know from registers or from views from our, for example, German colleagues, is time that is indeed often taken by the register. So if you're looking at a cross-border context, you will indeed be adding up to 3 months, if not more, if there is a risk, that the register is not comfortable with the transaction, or to your timeline. In Luxembourg, from what we have heard from notaries for now, is that they expect to remain as pragmatic as they are, to the extent that they receive the merger plan and the underlying documentation slightly in advance. They will be able to take a view rather quickly. So I think it is fair to assume that in a standard context where there is no risk that there is indeed a judgment that this might be abusive or fraudulent, we can expect that from a Luxembourg perspective, the timeline will not be extended too much, but the reality is that in other countries, there's this potential 3-month extension. In addition to that, we have a second step, legality control, which is undertaken by the register or the notary of the receiving country after the holding of the general meeting, because, and I should have mentioned that this pre-merger certificate at the end of the pre-merger control is issued and is then handed to the notary or the register at the end of the general meeting, and you can see it on the slide. Well, following the general meeting, the notary or the register of the receiving country will need to do another legality control for the receiving country, because that has not yet been done, which again covers the same matters for the receiving country and can again take 3 months. And this is painful, right? If we think about this, 3 months with potential extension. Again, from a Luxembourg perspective, we take the view, and based on our discussions with notaries, that this should be relatively quick unless we are in a particularly complex situation. But in other countries, we do need to work on the assumption that we have a 3-month period. So, Mélody, let's do the math. Before we were looking at, in terms of fixed timeline, 1 month, 1 month waiting period. Obviously, we know preparation, etc. It takes longer, but it's 1 month. Now we're looking at 6 weeks, so that's plus 2 weeks. Yep. 3 months or more, but let's assume we are looking at a plain vanilla transaction, plus 3 months. So we're looking in total at 6 months plus 2 weeks longer than initially. Okay, that is the situation. We cannot change it. This is the European directive as it is implemented and as it is foreseen. The idea behind this is, of course, to avoid fraud, avoid abusive transactions, and to provide a certain legal certainty and a certain harmonized setup in all EEA countries.
And I guess it's also worth mentioning that Luxembourg wanted to remain competitive and transpose the directive in a way that it was the entire directive, but only the directive, without being more strict or stricter in its requirements.
Exactly, which is not the position that was taken by every other EEA country, unfortunately. But in Luxembourg, we did indeed take a very pragmatic approach here. Another little change is that we have a creditor protection period that now runs for 3 months from the publication of the merger plan, and Blazej will speak about that in more detail in a second, and applies only to debts that are not due at the moment of the publication of the merger plan. This is a difference to the internal merger and non-EEA merger, where there's no mention of debts having fallen due or not. In a domestic context, we previously had the 2-month period after the general meeting. So if you look overall, actually this is not, and anyways, this doesn't have a suspensive effect, as you know well. So this will in reality not affect the timeline too much, I guess, but it is still something to be considered that we now start this period earlier on in the process. The effective dates for an EEA cross-border merger is for among the parties as soon as the notary certifies or the register certifies the merger following the second step legality control, and towards third parties upon publication of the general meeting. Noting, of course, always, and this is what the directive and the law has now also specified, is that the receiving country's law will determine the actual effective date. This was in practice a reality before already, but now it has been clarified. For demergers, and you will note that I focused on mergers because I think we all agree this is what we mostly do, right? Demergers are slightly rarer, even though we do, of course, work on them. So I've sometimes mentioned demergers and mergers, and indeed the changes are broadly similar. We now also have expressly covered the EEA demerger by separation, and you might recall previously that not every other country accepted cross-border demergers, so we often had to apply this 2-step approach where we went via a domestic demerger and then a cross-border merger. Well, now at least we have an express coverage of an EEA demerger by separation, so a demerger by which a new company is created. But the demerger by absorption is not expressly covered. So from a Luxembourg perspective, that will be covered by the regime applicable to non-EEA and domestic demergers, but we will again be in a situation where if an other country, the country to which we want to move, does not accept a demerger by absorption in a cross-border context, we will again possibly be obliged to run this 2-step process. Okay, let's look at conversions or migrations. I cannot stop calling it migrations. It's just something that is so deeply in me, but I will try to stick to conversions because that is what is now the correct term. As Mélody said and as I said before, those were previously based on ECJ case law. There was no statutory regime, be it for EEA or non-EEA conversions. Now we have an express mention of non-EEA conversions, cross-border conversions in the law. There's not much formalism being included in the law, so there will not be much change compared to this as we previously had. In fact, if we have a non-EEA conversion, we will still be looking at simply at the general meeting approval. But for no, let's go back. Yep, sorry. For an EEA cross-border conversion, we are now going to look at a certain number of formalities that are strongly aligned with what I just explained for mergers and demergers. So you need to publish a conversion plan. You need to have a board report with two sections, one of which is waivable, one of which is not required in the event of a sole shareholder situation. You need the experts report, again not required and waivable in sole shareholder situation. You have the 2-level legality control, as I explained. You have minority shareholder cash out right, which I, by the way, forgot to mention, but Blazej will make sure to mention that in a second. minority shareholder right and the creditor protection period. As said, there's the same possibilities for waivers and exceptions as we just discussed. To be noted, of course, that the rules of the departing countries will govern the formalities applicable. So if Luxembourg is the departing country, the formalities up until the approval of the conversion in the receiving country will be governed by Luxembourg law and will be as I just set out. If Luxembourg is the receiving country, however, we will of course take a passive role until the moment at which we are due to approve the creation of this converted company, and it's constitutive, even though of course we agree the company continues with its legal personality, but we take a passive role until we receive the pre-conversion certificate from the foreign register or notary, and then the Luxembourg notary will approve the creation of that converted company, will approve the conversion, and then will carry out its own legality control here in Luxembourg and then render the merger effective. There is also a creditor protection period, and Blazej, you'll speak about that. Again, there's this mention of dette non échue, and there's a 2-year passive survival in the departing country that I'm sure you will also speak about in a second. That is it from my section. I think you'll see that there's quite a lot of things to remember and to take into consideration. There is also the need for, of course, close discussion with if you're looking at a cross-border situation, with your local council in order to determine how long you need to count for the for the legality control carried out in the other country in order to determine an appropriate timeline that can be communicated to the client. Blazej, over to you. Let's take a look at stakeholder protections.
Thank you very much, Victoria. Yes. Thank you very much. Indeed, this is the last major part, I think, of our today's presentation, and we wanted to talk about it specifically because I think it has an impact on our current corporate landscape in terms of cross-border operations. And you both mentioned a lot of elements that I will now restate again, but I think it's important indeed due to the importance of and significance of these changes. So indeed, the Mobility Directive and our implementing law here in Luxembourg focus on 3 main groups of stakeholders that are entrusted with specific protections in the context of cross-border processes. These are shareholders, obviously, the creditors, and newly the employees. So in relation to the shareholders, obviously, next to the pre-existing, if I may say so, protection measures that we know from our national domestic regime from the past, such as the management report, the independent expert report, also the delivery of preparatory documents at the registered office of the company. So all these remain valid. But next to those, we have now certain specific rights that have been entrusted with the shareholders, and in particular, indeed, the right of withdrawal for those who do not want to continue with the company post cross-border operation. So this is a new possibility for the shareholders that voted against the operation at the general meeting. They have now a possibility to actually transfer all the shares to either other shareholders, to the participating companies, or to an agreed third party. The law states that indeed that should be all shares. However, the common draft terms of merger, division, or conversion can potentially foresee an exception to that. And the law also foresees that the exercise of this right is triggered by the fact that at the general meeting, actually the shareholder voting against is declaring to the notary that he or she is willing to exercise this specific right. Once the right is exercised, the shareholder is entitled to a cash compensation, obviously, for these shares, and this compensation has to be paid within 2 months as from the general meeting approving the operation. In addition to that, if the cash compensation which was foreseen for the transfer of shares is actually not adequate in the eyes of the leaving shareholder, that shareholder has also a right to actually challenge that and claim additional compensation in front of the district court, competent district court in this respect. So this is in relation to shareholders that have actually voted against and that are not willing to participate in the post-operation situation. However, the law foresees also some specific rights to those shareholders who voted for the operation or are willing to stay and remain with the company. They have now a possibility to actually challenge the share exchange ratio, which is described in the common draft terms, and request thereby an additional compensation in cash. So this right indeed is open to those shareholders. They have 1 month following the general meeting to actually initiate this procedure in front of the competent court. And indeed, the company is actually free, or the involved companies are free to compensate or to provide additional compensation if such is ultimately decided by the judge in another form than cash. So here even the issuance of new shares could be potentially envisaged. So all those actions have no suspensive effect. They are considered and they have been drafted not as blockers to the operation as such, but more as a tool for the shareholders to somehow ensure the defense of such shareholders' financial interest, basically.
So I guess, Blazej, in reality, I think we will all agree the majority of operations we do of this kind are, of course, intra-group, and there's rarely a minority shareholder. So this is not going to affect us on a daily basis. But in a situation where we are looking indeed at a big company, at an operational company, with minority shareholders that do not necessarily agree, this is something that is going to be very important and might have a quite big effect on the economics of the operation.
Absolutely, absolutely.
So this is indeed quite an important and strong change and creates a certain level of uncertainty, at least around the timeline of the transaction for the company itself.
For sure. But then, on the other hand, if there are some dissenting shareholders, obviously it's better for them to leave, to have the possibility to leave the company rather than stay in a more conflictual, if I may say so, situation afterwards. So indeed, it's something new, and we didn't have that in such an extent in our Luxembourg legal framework. However, on the top of that, there is yet another, if I may say so, new right that has been granted to the shareholders currently. It's a consultation right, if I may say so, which consists of the fact that the company will now always be obliged to publish a notice to the shareholders, to the creditors, and to the employees, whereby it will inform them that they have actually a right to comment on the common draft terms of the cross-border operation. This is also very new, because instead of being simply passive or defend their own interest, they can now also proactively actually address comments and remarks to the company in relation to the common draft terms. And this is indeed something new, something interesting, and I think hopefully the shareholders will make use of that.
Yes, and in reality, I guess this is indeed, as you say, to inform shareholders of their rights. Question, will they see this? Will they, because the publication has to be done at the same time as the merger plan in the RCS.
Correct.
And the RESA. So it needs to be hoped that they will actually be made aware of this and see this. But then again, you can say, well, priorly it was also only published in the same manner, the merger plan, and indeed, as you say, they were not aware of their rights necessarily, and they had a much more passive role per se.
For sure. Indeed, so the law foresees only publication with the SES. The practice will show to what extent, indeed. Maybe some companies will decide to also inform their shareholders proactively via other forms, or via other means of communication. That remains to be seen. The law obviously sets a minimum. That same, if we talk about it, that same rule applies to the creditors. So the creditors will now also be able to actually comment on the draft terms of merger. This is very new because indeed the role of creditors within the migration, merger or demerger process was very passive so far. Now it is changing. This consultation right is also present for creditors. But I think what is changed the most in relation to their ability now to act is what you mentioned, the safeguard period, which is now slightly longer than it used to be, that the one we know from the current domestic situation. It will start running on at the day of the publication of the common draft terms, so earlier as well, and it will entitle the creditors who are worried and who are able actually to justify that the potential operation, cross-border operation, will jeopardize the recovery of their claim. They will now be able to seize the district court and request additional safeguards in this respect. As you mentioned, only claims that predate the common draft terms of merger and which are not due at the moment of the publication of such terms will be eligible for this protection. And as such, the action will have no suspensive effect. And so again, it's not about blocking the whole process. It's more about actually ensuring that the creditors have their financial rights protected. Last but not least, and I wanted to talk about it because indeed it's the biggest change, if I may say so, in relation to this protection of stakeholders, is the role that is now played by the employees themselves or by the representatives of the employees, if there are such at the level of the companies. So here, alongside shareholders and creditors, the employees will now have the right to comment and send the remarks to the company about the draft terms of merger. They will be able to do so, just like shareholders and creditors, up to 5 days before the general meeting of shareholders deciding on the respective operation. And their role will definitely increase in the process because they will be definitely very much concerned by the operation as such. And I would expect that this would be the group of stakeholders that will indeed have the most remarks and opinions to communicate to the company. But in addition to that, and you mentioned that, Victoria, as well, it's very important that now the employees will be the addressees of a specific report from the management board, which was not the case until now. So it can be either a section of the report that is being sent to the shareholders or a separate report. So these options exist for the management. And the content of such report is also described in the law quite specifically. So it has to opine on the employee arrangements that have been determined in relation to the operation. It has to also speak about how the employment relationship will be preserved after the operation. And it has also to include all the material changes to the employment conditions for the employees of the merging companies, as well as their subsidiaries. So the content of the report is extremely heavy, and as such, indeed, it will add some additional work to the management that is willing to perform a cross-border operation. Nonetheless, it's extremely important that the employees see that they are taken care of, and as such, I think that justifies the production of this report as well. So these are the main, I would say, stakeholders that are now protected in the context of cross-border operations. Now, last but not least, and we've discussed this a bit already, I think the biggest reshuffle or even revolution maybe with our implementation law and Mobility Directive is the role that will be played by the notaries in the process. So indeed, the migration or mobility, directive foresees an increased scrutiny of the legality of the process. So here, indeed, there has to be a true control, a true verification of the formalities. And the scrutiny's role has in Luxembourg been entrusted with the notaries, as you mentioned. So what would be the role of the notary? The notary will control the operation both from independently of whether the Luxembourg is actually the country of departure or country of destination in the context of the cross-border operation, as you rightfully mentioned. However, I think the role of the notary in the context of the situation where Luxembourg is the departure country will be slightly more formalistic, slightly more important, if I may say so. So what would be the role of the notary? First of all, to scrutinize the legality of the operation and issuing a certificate, pre-operation certificate, so the pre-merger, pre-division or pre-conversion certificate, attesting that actually all the formalities, all the procedures have been properly completed by the companies participating in the cross-border operation. So in terms of process, the whole scrutiny will start with an application that it has to be made by the participating companies to the notary, and which can be made virtually, so electronically only. That application has to include specific number of documents that have to be provided to the notary, so the common draft terms, obviously, but also any comments that have been received by the companies from the stakeholders, as well as any reports of the management, and also the outcome of the general meetings of shareholders. So all these have to be sent to the notary, and then, as from then, notary has 3 months, as you mentioned, to actually analyze whether the operation has been performed properly or not. In this respect, the notaries are required to perform normal due diligence, and they have a full right to actually consult with either independent experts or authorities that could be competent if this is required or needed to ensure that the analysis is properly performed. We expect, from a practitioner's point of view, that might indeed also involve that the notaries would request additional confirmations from the management in terms of confirmation letters, but potentially also legal opinions from the company's counsels. The practice will show. I think in the upcoming months we will know more. Now there are 2 potential outcomes of the scrutiny by the notary. If the operation is in order, then the notary issues the pre-operation certificate, which then is filed with the Luxembourg Trade Register, and after that also communicated by the register directly to the authority of the country of destination. So this is the best case scenario, obviously. However, the notary may also refuse to actually produce the pre-merger certificate as soon as the notary realizes that actually either all the procedures were not properly respected or completed, or, as you mentioned, if the notary considers that the operation is conducted for abusive, fraudulous reasons, which then violates European law or Luxembourg law.
And I guess, Blazej, worst case scenario, that refusal can happen after 6 months.
Yes, indeed. So as I mentioned, the process is typically should last 3 months, but the notary has a possibility to extend actually this period for 3 additional months, which makes the whole thing last 6 months. Hopefully that will not happen that often, but indeed, yes. And that's also the purpose of this procedure. is to ensure that all cross-border operations are now within the European Union performed in accordance with law and not for any frivolous reasons. So imagine that the notary refuses to issue the pre-merger certificate. The company has actually two possible ways to react to that. So if it is about not fulfilling some procedures or some formalities, then the notary will issue potentially some recommendations to the company on how to complete the procedure and what the company has to do to pass over the line, basically. And the company can comply with these recommendations, which would then deblock the whole situation. If the company does not agree with the statement of the notary and the appreciation of the notary, the company has actually a possibility to challenge the refusal, and it can do so within 8 days as from the notification of the decision of the notary in front of the district court, competent district court. So this is the new situation, specifically in the scenario where Luxembourg is the country of departure. However, if Luxembourg is the country of destination, that also means that the notary will be involved. As I said, I think the control will be limited to the extent that a pre-operation certificate will be issued by the authority of the departure country. So all this work will be done already in the country of departure. And the notary will typically, in this context, focus on whether the cross-border operation has been approved within the same terms in both jurisdictions. The notary will specifically analyze the arrangements for employees, whether they have properly been determined in the cross-border operation. And it will scrutiny to what extent the general meetings have been consulted as well. And once the notary actually confirms that everything is in order and accepts the pre-merger certificate from the other authority, then the merger is effective, as you mentioned. The pre-merger certificate should in principle be accepted as is by the notary here in Luxembourg, unless there is a manifest error in it, in which case indeed the notary can refuse and request the company to actually correct the error with the competent authorities. So all that to say that I think it's a revolution for the notary. It's a new era for the involvement of notaries in the daily life of companies in the context of cross-border operations. So that's also the reason why we wanted to emphasize this very, very specifically. And I think that's it on our side.
That may seem scary, but I guess with when we talk about or think about private equity players and private equity houses, the risk that there would be an extension of deadlines by notaries and fraudulent purposes is probably very remote.
Yes, and ultimately it will also depend on us as counsel to ensure that the notary is taken on board sufficiently early in the process and that we make sure that the documentation is up to expectations of the notary. One thing that sprung to my mind as you were speaking, Blazej, is that part of the legality control of the notary is to compare whether the merger plans or the conversion plans published in both countries, participating countries, are identical. And I'm sure you also already had that situation that other countries like to publish accounts, like to publish articles, which of course we also do as annexes to the merger plan or the operation plan. And often the accounts are in a format that is not accepted by our dear RCS, because the margin is not exactly 3.73 centimeters, and because there's maybe different colors. And typically what was done in the past in these situations is that we simply remove the accounts, it is referred to as an annex, and that everything is fine. But this is definitely something that we will need to consider now and see how we find a solution to that, and or discuss with the relevant registers or notaries, because remember that this is not only about the Luxembourg notary, but also about the foreign register, how we can make this work. So this is, I think that what obviously, and Mélody, you probably were going to say this is all something that the future will show.
Sure, that's why it's so exciting actually. The upcoming months will be very interesting in terms of how these rules will be implemented in practice.
Exactly.
Until it's rules. So I guess we can wrap it up now. Thank you so much for attending this webinar. In case you have any questions, please feel free to reach out to the LPEA and we'll be happy to get back to you separately.